there as it is in Missouri. As well, 2009, then Auditor Monty issued a memo that said that this was very unclear and that the state needed to clarify it, or the department needed to clarify what was and was not an independent contractor. In our instance, I understand what you're saying about the an employer doing that. That is not at all what we did. We actually talked to the department when we established business in 2004. They told us that how we were structured was correct. Then this audit came up. We met with the department in Representative Barr's office, and they told us then, yes, you were correct when you started. However, internally, we have changed how we look at it. And they didn't issue those changes to anybody. The law hasn't changed, it's just how internally they look at it has changed. And that's where the clarity, I think, needs to come from.
Thank you, sir. But those opposed to the bill?
I have friends.
Maybe others too. Mr. Chairman, Ray McCarty, President of Associated Industries in Missouri. We'd like to go on record in support of this, primarily because we represent employers in the state who would like the certainty that would come from this. Trying to decide whether an employee or an independent contractor is being contracted with business is difficult. So we'd appreciate any surety that can be brought to the equation. This provides for a rule and also for an opinion letter. Happy to answer your questions.
Thank you very much.
Good morning, Mr. Chairman. Brad Jones with the NFIB. I think probably next to health insurance questions in our office, we get this one probably as much as any dealing with independent versus. And we've got the smallest companies that have been dealing with this. I'm not calling it an inconsistency. We understand the 20-point test. But as Representative Barr did a lovely job explaining, this is really something that I think a lot of small companies would really appreciate. There being a bright line on this as to what they're supposed to do. So, thank you, and I really thank you for bringing this forward. So, thank you.
Do you happen to have any information on what was the result of Auditor Monte's asking for clarification? Did that just not get done?
I don't know, Mr. Chairman.
Okay, thank you. Others to testify for the bill? Those testifying against the bill?
Mr. Chairman and members of the committee, my name is John Boyd. I'm an attorney from Kansas City. I'm appearing here today on behalf of the Missouri AFL-CIO. Formerly, when I started my law practice, the area of independent contractors I became familiar with and started advising companies as to whether or not potential employees could be so classified. Over the years, I became a workers' compensation judge and later acting chair of our Labor and Industrial Relations Commission. I've seen the evolution of this, and I've seen the phenomenon grow of employee misclassification. Now, employee misclassification, 1099 misclassification, is a major problem, not just in Missouri, but across the country. What you have is the avoidance of local taxes, withholdings being paid either to the state or earnings taxes to the local communities when individuals are wrongly classified as independent contractors. The tests are published, they're IRS tests, the 20 elements that we're talking about, and they're published on the department's website. Secondly, it's not so much what we want to call these projected employees or independent contractors, but rather it's the substance of how are they utilized. In other words, it's the control. It's not what we call them, it's how do we use them. If we use them as employees, then they should be compensated as employees with taxes withheld, paid to the state of Missouri and obviously the federal government. So what happens is we don't receive the FUTA contributions first. Secondly, if they are independents, they may not file estimated quarterly returns. And the phenomenon continues to compound where local communities and the state are foreclosed tax opportunities. This bill, by giving a pre-authorization as to whether or not what you intend to set up is an independent contractor or an employee, is about form, but not about substance. It's how you implement those people and use them as elements of control in the 20 questions that has the flexibility built into it. As a result, the Missouri AFL-CIO testifies in opposition. Thank you.
Thank you very much, sir.
Is the department going to testify on this bill?
I have no idea. Is there someone from the department that wishes to testify on this bill?
Or will you be?
Not planning to.
Okay, good have a question.
Would the next witness, please?
Mr. Chairman,
Very briefly.
so my worry is exactly what you had brought up. I was out of the hearing room, but so the problem I see with the bill to get that existing letter up front is you're guessing what these folks are going to be doing, or maybe you have a good idea what they're going to be doing, but until you actually put it in motion, until the business begins and then employees doing the job, very much can change, correct? So I know that the department has investigated places before, and then a couple of years later, go back, actually several years later, went back and they did not pass the test for independent contractors, although a few years before they had. It's just a matter that the jobs had. My question is, I guess, do jobs change in that manner where we can have someone actually being an employee at one point, but being an independent contractor or reverse? That by the direction of the boss is being told what to do, how to do it, what time to be here, what time not to be here. Those things do happen?
Frequently.
Okay, thank you.
Next witness, please.
Mr. Chairman, hi, my name is Fred Bryant, and I'm an attorney from North Kansas City, Missouri, and I'm a small business owner, as well as my wife formerly was a small business owner of a daycare. I'm also here on behalf of the Missouri Association of Trial Attorneys. We are opposed to the bill. We would be willing to work with the sponsor on some of the matters that we're opposed on, specifically the classification. We think if the bill is currently written, is subject to abuse possibly, where you could just, anybody could say they're an LLC without really the control issue, such as Mr. Boyd brought up, is something that's very clear in Missouri law. There's not I don't think the department in the way that they have managed this in the past is in an adversarial relationship with small businesses. I think they do everything they can to help. As Mr. Boyd mentioned, they do have on their website, the Department or the Division of Employment Security, manner of classifying employees, which is fairly clearly written. It talks about the issue of control. It also discusses that the Division of Employment Security looks at these things on an individualized basis to look at the various factors that are under the 20-point test, which the IRS utilizes and which is utilized here in the state of Missouri. And the department has also made clear that any business that has questions, they'll be glad to answer them. They're not in an adversarial position, but they do wish to clarify any misconceptions businesses may have so that they are properly classified, because misclassification is a problem here in the state of Missouri. There were 923 employers that misclassified employees last year, which ran over $1.6 million in costs to the state. It's been estimated on the website for the Division of Employment Security that there's over $10 million in lost revenue because of misclassification. So I think this bill needs to be tweaked at the very least so that we can avoid any abuses in these pre-authorizations of employees so that we don't have misclassification issues. And that's why we're opposed to the bill. And I'm open to any questions that committee members may have.
Thank you, sir.
Thank you.
Next witness, please. Are there any here who wish to testify for information purposes only? Okay, that closes the hearing on House Bill 1642. We'll now hear from Representative Hart. That would be House Bill 1663.
Morning. For the record, my name is Representative Elijah Haar of the 134th District in Springfield. This morning, as you mentioned, I am presenting House Bill 1663. This is, as far as words go, a fairly small bill, and what it does, I believe, is correct in equity in the law. Currently, in a workers' compensation case, if an employee violates the safety rule, their workers' compensation benefits can be reduced anywhere from 25 to 50%. If an employer violates a state statute or OSHA regulation or something along those lines, the benefits can be increased 15%. What I am attempting to do in this bill is to create an equal penalty for both the employee and the employer of 25% across the board. In my opinion, it corrects what I believe is an inequity in the law, as well as provides some more stability. A 25 to 50% penalty, there's no definition for how a judge is to determine whether to award 25, 35, 45, or 50%. This would provide stability for the judges and equity in the law for the employees and employers. If the committee has any questions, I'm more than happy to answer them.
Have we any questions? Representative Swan,
To inquire.
please be brief.
Thank you. Yes. Good morning, Representative. Is there a provision anywhere that, I noticed the language in here indicates for using safety equipment provided, if the safety equipment is provided but it is not used properly?
And what's your question?
I see that the language pertains to the use of safety equipment provided by an employer.
Right.
What happens in the instance when the equipment is provided, but it is not used properly by an employee?
I've got witnesses that can probably answer your question better than I can. Mine only has to do with the percentages. It doesn't have to do with the use of it or anything like that. But I have witnesses that probably can answer your question.
Just an additional complication that kind of clouds things. Thank you. Thank you, Mr. Chair.
Other questions? If you'd like to bring your first witness, please.
Mr. Chairman, Fred Bryant again. North Kansas City, Missouri. I'm an attorney. I'm here in support of Representative Haar's bill. I've been representing injured workers for over 31 years in my practice, seen thousands of injured workers, and some unfortunately have been injured when the employer shortcut a safety rule, such as removing a machine guard or not adequately maintaining machine shutoffs, things of that sort. This bill, by increasing the penalty, provides greater incentive for both the employer and the employee to obey safety rules and regulations. I agree with the representative that it does provide equity and that now both employers and employees are penalized in the same degree. It provides stability, and that we know that as an employer, you can judge whether or not it's going to be worth your while to provide a safe place to work for the workforce. In answer to the Representative Swan's question about a provision concerning equipment provided and not used, I think the bill as written already provides for that, in the sense that if the employer would publish the rule as to using the equipment and the employee does not do so, then they would be subject to the same penalty that the representative has set forth in his bill. I think this bill would promote and emphasize workplace safety by providing an incentive, the possible penalty. It does not raise costs because it's the employer's prerogative then to obey safety rules and safety regulations. It brings the obligations of the employer and employee in line with one another, safety responsibility on each side, and obviously what we all want is a safer workplace for everyone involved. And with that, I'll open to any questions from the committee.
Thank you, sir. Next witness, please.
Mr. Chairman, members of the committee, my name is John Boyd. I'm an attorney. I represent today the Missouri AFL-CIO, and we testify in support of this measure. I would point out one thing, that an employer has to violate a Missouri state statute or an order of the Division of Workers' Compensation or the Labor Commission in order for the penalty to apply. It does not apply to an OSHA violation. Thus, very specific state law or an order has to be violated by the employer before the penalty could be assessed. And the violation has to be the prevailing cause for the resulting injury. In the employee who violates a rule or regulation or a law, it's a broader potential area of exposure for which benefits can be reduced if that employee violates those, even though it may not be knowingly violated the way this bill currently, the law currently exists. So I wanted to point that out for information purposes to be Representative Swan's question. Thank you.
I kind of find this to be one of those bills that's accomplished the impossible so far. It's got something for both sides.
So you've been shutting me up, I'm sorry. This is short as possible.
That's here. Next witness, please.
Mr. Chairman, Mike Lewis, I couldn't have said it better myself. Thanks for your testimony.
Are there others here who wish to testify in favor of the bill? Are there those opposed to the bill? That's also a rarity in this committee. Those that wish to speak for information only? Thank you very much, Representative. This closes the
Mr. Chair,
hearing on 1663.
if possible, I'd like to speak considered as a consent bill.
Go ahead.
That's all.
Is Representative McGaw with us?